Matter of State versus Ferriter.
Morning, Judge. Karam Wahid and Priya Murad for Mr. Ferriter was present.
All right, let me have appearances, please.
On behalf of the state, Your Honor, Brianna Coakley and Karen Black.
All right, we're here for the third day of trial with opening statements slated to begin this morning. Anything I need to address before we get started?
Yes, the defense has provided me a video they intend to play an opening statement. The state objects to it. And it's a 5-minute video that includes a lot of photographs that the state montages, videos that the state doesn't believe will come into evidence. They're not relevant. They're prejudicial. And so we would object to them being shown to the jury at this time prior to Your Honor making an evidentiary ruling.
All right,
I can show it to the court.
What's the basis and how does it not amount to just good character type evidence?
So, Judge,
That's the primary concern I have after coming out of the hearing yesterday when you told me that you had 200 photos.
that's not, I understand that, Your Honor, but this video is only 5 minutes. I would say the second half of it includes ring videos that were disclosed by the state in discovery. So the beginning of the video includes some family photos and videos. And the reason it doesn't amount to good character evidence is there's an intent element here.
I understand that, but it doesn't mean you can put in evidence of good character to negate an intent element of a criminal offense. So
It is kind of different here because the issue is parenting, right? And they're trying to say that there's a time frame in which, and they're going to show limited videos of the relationship between parents and children that say this is abusive because of the way in which that this particular conduct.
where's your client?
I think Mr. Wahid is getting him, Judge.
All right, we should have him present for this argument. All right, so court knows that Mr. Ferriter is now present. So go ahead, Ms. Moran.
So, Judge, it's a short video. I don't believe that it's cumulative. I'm happy to show it to the court. It's primarily things from after Ronan was 10 years old, and it's only for opening. And again, I would ask the court to consider that the second half of it is just ring videos that are disclosed in discovery. So the fact that the state is able to play videos of him in a room or doing things that they deem abusive, the only way for us to counter that is to offer context as to what the rest of his life was like. Otherwise, it's just them yelling at him or putting him in a room, right? Like any parent, if anyone's worst parenting hits were recorded on video, I think everyone would seem abusive. So we have to be able to offer some level of context. I understand that the court can sort of tailor that so that it's not cumulative.
The most pious individual in the world could be a great, upstanding, moral individual, but if that individual, despite his piety or great character, commits a single act that results in a criminal offense, my understanding of the law is that evidence of piety and great character doesn't come in to negate the criminal offense that has occurred. So how is this different from that?
Because that piety is irrelevant to, if someone shoots somebody and murders them, the fact that they served food at the food bank is irrelevant. In this case, we are being asked to make, or the jury is being asked to make a decision about whether or not a parent had the intent to commit abuse and whether or not that abuse was already committed. So it's not just good character evidence. It ties into the facts because this relationship is relevant. It's like,
So let me give you some context, and I'll give you an opportunity to make your argument. Let's say you want to show pictures. I haven't seen them yet, but you want to show pictures of the defendant and his son, him taking his son to a basketball game or soccer game, him playing catch with his son, doing father-son types of things. How is that relevant to the issue of whether he's guilty or has committed the criminal offenses of which he's alleged to have committed in this case?
because as the jury said yesterday during our discussion of criminal intent, there's no, if Mr. Ferriter does not testify, right, the only way to determine his intent is his conduct. And if the only person that's permitted to admit conduct is the state, then we have no ability to negate what that intent is and show, no, this is a family with ups and downs, and there were issues that this child was facing. But that doesn't mean he was unloved or uncared for.
But it doesn't matter. It doesn't matter.
It does matter.
How does it matter? It doesn't matter whether he's loved or unloved. If the criminal offense is false, let's deal with false imprisonment for instance. If the criminal offense is false imprisonment, and the allegations are that he placed his son in improper confinement that amounted to alleged false imprisonment, Doesn't matter whether he loved his son or not. That's irrelevant. It's
Well, actually-
did he stick his son in a facility or structure that amounts to, under the law, false imprisonment? That's the issue, isn't it?
So I think that's different for the false imprisonment charge than it is the aggravated and the neglect. So the false imprisonment charge is sort of a different, I mean, I still think there's an intent element there, but I understand why there's a little bit more clarity as to what constitutes false imprisonment. But what constitutes child abuse is different, because there's a lot of stuff that parents are allowed to do that does not constitute child abuse, unlike false imprisonment, where there's a lot more clarity. And there is a maliciousness element. The state spent an extensive amount of time talking to the jury about what does maliciousness mean to you. If all they see are the state's videos, that's what they're going to think.
All right.
I would like the court to view the video. It's 5 minutes. I need to put it in the record anyway. And if the court is not inclined to permit me to play any of it, I would ask that the court permit me to play the videos that were disclosed in discovery by the state during the course of time.
Disclosed, counsel, disclosed in discovery is not the barometer or the measure by which you're allowed to present it to the jury. There's a lot of stuff disclosed during discovery that is not admissible at the trial. So let me make this simple. If there are things in this video that are not coming into evidence at trial, I'm not going to allow you to show it. But do you believe you're going to be able to overcome the objection? Because I assume there's going to be an objection to these things coming into trial. And if you're going to show them evidence that I know that's not going to come in during the trial, I'm not going to allow it in opening statements.
So my position, based on the argument that I'm presenting to the court, is that it should be admitted. And so I think the court needs to view it and make a pretrial ruling. And I know that delays the jury. We could either do it now or bring the jury, do the instructions, state do their opening, and then give them a short break, because I know they've been waiting. It's a 5-minute video. I'm happy to email it to Your Honor's judicial assistant so the court can even watch it in the back. And then perhaps there are portions of the video that the court would allow. Because I understand what the court is saying, that just because, of course, something's in discovery, we depose on all sorts of stuff and it's speculative, it doesn't come into evidence. However, in this particular situation, there's a 4-week time period. That's it, within which the state is saying that certain conduct happened that amounts to aggravated child abuse, child neglect, and false imprisonment. And so there are other videos during the course of that show that there is no malicious intent. So if we do not have the ability within reason, and I understand if the court makes a ruling that too much of it is cumulative, but if we don't have any shot at explaining, then
So your position, back to my hypothetical example. Your client takes his son to the basketball game on a Saturday afternoon. Great day. They're laughing, smiling, having a great old time. Brings him back home and puts him in, allegedly, in this structure, locks the key from the outside. I'm concerned that you're kind of going down a path of saying that taking the child to the game and doing the father-son thing somehow justifies or explains putting the son allegedly in the cage, and that I can't connect those dots.
that's not the defense.
All right, so what is the relevancy of it then?
Well, first, I think that the issue is the court's understanding of the room and how it was utilized. So first and foremost, the defense's position is that it was utilized primarily for supervision. In his own deposition, Ronan said it wasn't locked all the time. This is mainly in the evenings when he couldn't be supervised. And we're still working on putting it all together, but that will be presented in the defense case in chief based on the videos provided in discovery. And I do think that's relevant. So how can a jury make a determination about the relationship between a parent and a child without some context as to what the relation? It's like a self-defense. You have to have context in order to explain conduct.
And they got to do it based on admissible evidence. If there's not admissible evidence, then they may not be able to make that connection. But it still boils down to both sides having to work with what is admissible in this case. And that's my job as the judge, to ensure that what comes in is admissible and what's presented to them is admissible. And I have significant concerns that what may be in this video is not admissible. Here's what I'm going to do. I'm not going to spend any more time on this. Email it to my chambers right now. I'll review it, and then I'll come back out and announce a ruling. So the court's going to be recessed for 10 minutes for me to review this video.
Mr. Wahed, he has an argument
Just
to add. I
just want to add one thing, Judge. First,
All right, so let me make sure that we have a proper protocol here going forward. One spokesman per side per issue. So if you take the lead, Ms. Murad, I'm only going to hear from you. I have no problem with Mr. Wahed taking the lead, and I'll hear only from him. But I don't want to have this double teaming, and so my procedure. I will go ahead and hear your comment at this point because I didn't advise you of that prior to this instance. But going forward, I'm only going to hear from one side, one spokesman for each issue. That means you can alternate whatever issues you want to discuss. All right, go ahead, Mr. Wahid.
Thank you, Judge. First, in terms of admissible evidence, you definitely have RF who's going to be able to speak to those photographs. So that evidence would be admissible at the very least through RF. So he's aware of those things. He was asked about some of those things in deposition. He admits those things. These pictures would be admissible through RF. Second, at least most of them. Second, because at some point he was too young. So obviously the ones where he's too young, he won't recall. Second, our defense, which is the affirmative parental defense, there's an issue of reasonableness, of reasonable parenting. And that requires context. It requires the jury to understand. And just for the court's information, what's going to come out through both a state expert and a defense expert is the escalating history of the family dealing with RF and his mental health issues throughout the course of his life. And it's important because the state is essentially putting forth that he is in this room all of the time, or the majority of the time when he's not in school. And that has to be rebutted. This evidence rebuts that.
Well, I'm not sure I agree with you. I haven't said yet that I would knock out photos of perhaps the parents and RF going to a psychiatrist office, for instance, or going to a mental health facility. But that would be something that might be admissible, and it might be relevant to the response and the efforts of the parents to deal with the issues that they're having with their child. I get that. I get the strategy. But just simply showing a picture of the parents and the children having a good time at some point, to me, is not relevant to the specific issues that I have to decide in this case from an evidentiary standpoint. I'm not going to hear any further argument. Go ahead and email it to my chambers, and I will take a recess for 10 minutes. When I come back, I'll announce the ruling. All right, court's in recess.
Court's in brief recess. Back in session.
All right, everyone may be seated. All right, after reviewing the video of the proposed video of the defense in camera, court sustains the objection of the state. All right, anything else I need to address prior to the opening statements? Okay, all sides ready to proceed? Why don't we go ahead and get the jury started, and we can do that maybe after they break for lunch and take a few minutes at that time. Okay. All right, go ahead and bring them out. All right. So, all right, everyone may be seated. All right, ladies and gentlemen of the jury, welcome back. Trust everyone had a good evening. I apologize for the later than anticipated start, but I can assure you that while you've been in the jury room, we've been out here attending to matters that have to be handled outside of your presence. So just because you're sitting back there doesn't mean that we're not working out here to keep the case moving forward. So with all that being said, I do like to start as close to what I tell you as possible, but this morning it just wasn't feasible because of issues I had to deal with. I do have about 10 to 15 minutes of instructions to read to you before we start with opening statements. As with all the instructions that I will be reading to you during these proceedings, I ask that you give them your very close attention. You will be provided with a copy of the instructions prior to going into the jury room for deliberation. So you don't have to memorize anything that I'm telling you because you'll have it in writing. Okay, so we'll begin without further ado. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Timothy Dunn Ferriter. This is a criminal case. Timothy Dunn Ferriter is charged with aggravated child abuse and false imprisonment and neglect of a child. The definition of aggravated child abuse, false imprisonment, and neglect of a child will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Timothy Dunn Ferriter in accordance with the law that I will provide to you during these proceedings. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful for you to understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make what is called an opening statement. The opening statement gives the attorneys a chance to tell you what they believe the evidence will be presented during the trial. What the lawyers say, however, is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys, and documents and other exhibits may also be produced as evidence during the proceedings. After the evidence has been presented, the court will then give you the instructions on the law. The attorneys at that time will then have the opportunity to make what are called their closing arguments. Following the closing arguments by the attorneys, the court will then conclude with the final instructions to you. After the final instructions are given, and only then will you then retire to consider your verdict. You should not form any definite or fixed opinions on the merit of this case until you've heard all of the evidence, the argument of the lawyers, and the instructions on the law that will be provided to you by me at the appropriate time. Until that time, you should not discuss the case amongst yourselves and obviously with anyone else. Your verdict must be based solely on the evidence or lack of evidence in the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication, as you know already, includes no emailing, text messaging, tweeting, blogging, or any other form of communication that you can imagine in this day and age of high technology. You cannot do any research about the case or look up any information about the case or the people or places involved. If you do become aware of any violation of any of the rules that I've given you, please notify court personnel of the violation, and that court personnel would be my bailiff, whom I introduced to you during the first day of trial. During the course of the trial, the court may take recesses, and at that time, you'll be permitted to separate and go about your own personal affairs. During these recesses, however, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence, please ask that person to stop and advise them that you're on the jury trying the case. If he or she persists, leave that person at once and immediately report the matter to my courtroom deputy, who will then advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom, and that includes not putting them on vibrate. When we're in the trial, I ask my jurors to have your phones completely off because I want you to be focused on the evidence and not be distracted by vibrating either your phone or anybody else's. So I do ask that you turn them off completely. And as I said, turned off means that the phone or other electronic device is actually off and not in the silent or vibrating mode. So what that means is if you do need to have someone be able to reach you in case of emergency, my bailiff can give you the number that they can call, and any message will get to me very promptly. You may use your devices during the recesses, but even then you may not use your cell phone or other electronic device to find out any information about the case or communicate with anyone about the case or, again, the people and places involved. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure that your cell phone or other electronic device is turned off, as I've explained. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. And what that means is you cannot have in the jury room any cell phones, computers, or other electronic devices. And if someone needs to contact you in emergency, as I just said, the court can give messages and deliver them to you without delay. And that contact number will be provided to you by Mark if you need it. So once you go in to deliberate, you'll actually give your phone to my courtroom deputy who will guard it during the time period that you're deliberating. Remember, the case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own, and this includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to the case or the people and places involved in this case. And again, this applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, as I've already mentioned this to you before, do not let even your closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that you must not talk about this case face-to-face. You must not talk about this case by using any electronic device. And you must not use phones, computers, or other electronic devices to communicate in any way regarding this case. So do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. And let me digress for just a moment. The most often violated or the violation that occurs with respect to this rule is someone will innocently get on Facebook, post a picture of themselves and say, I'm on this trial for the next week, and this is what the case is about. That would be a violation of this, the rule. So stay away from social media at all costs during this week, and don't post or do anything regarding what you're doing and what type of case you're involved in. So what are the reasons for these rules? Because they're pretty strict and all-encompassing. These rules are imposed because the jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. And likewise, the parties have no opportunity to dispute or challenge the accuracy of what you may have found. And as I also advised you during the first day of this matter, doing anything outside of this courtroom would be contrary to our judicial system, which assures that every party has the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. So any independent investigation by a juror, as you can imagine, would unfairly and improperly prevent the parties from having the opportunity that our judicial system provides to them. Also, any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. Mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers, but also to you folks, because this is your third day of contributing your time and energy to this proceedings, and if there was a mistrial, all of the time you spent up to this point would have been lost and wasted. So again, this just underscores the importance of complying with all the rules. If you do violate these rules, as you know, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. It's rare, but it happens enough in the world that you need to know there are potential consequences if you do violate the rules. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence, and from the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. We spent a lot of time going over that during the voir dire. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, however, you should not speculate on the reason why it is made, and likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone and outside of your presence. It is impossible to predict when such conferences may be required or how long they will last. But when such conferences do occur, please rest assured that they will be conducted in a manner so as to consume as little of your time as possible. And what that means is that if I can do it up here at sidebar, I'll do it and you'll hear this noise. You've heard that already. And so that means that we can conduct a conference up here and you won't hear it. If it's going to take more than just a couple minutes at any sidebar, I typically will have Mark or my bailiff escort you back to the jury room where you can be more comfortable while I'm, again, dealing with matters outside of your presence. I note that everyone looks like they have a note, pen, and pad, so let me talk a little bit about taking notes during the trial. If you would like to take notes, obviously you may do so. On the other hand, you're not required to do so, and it's your own personal choice and decision whether you do take notes or not. Everyone does have a pen and pad that has been provided to you, so you should use that for any notes that you do take. Please keep in mind that if you do take notes, that the notes will be for your own personal use, but you won't be able or permitted to take them from the courtroom. During the recesses, my bailiff will collect your notes and then pass them back out to you when you return to the jury box. After you've completed your deliberations, the court deputy will then deliver your notes to me, at which time they will be destroyed. And I can assure you that no one will read your notes. So they're for your own private purposes, for purposes of what you're doing as jurors in this case. I would tell you, though, if you do take notes, don't get so involved in the note taking that you lose focus on what is being said from the witness stand. If those have been in college or high school, you can remember those times where some of us tried to write down each and everything the professor or teacher said, and in the process of trying to write down everything, we lost track of what was being said. We don't want that to happen in a criminal trial because it is very important for you to listen to and hear everything that's being said from the witness stand, because that testimony is the evidence by which you will be guided in your determination as to the ultimate verdict in this case. Lastly, whether you take notes or not, you should rely on your own memory of the evidence, and you should not be unduly influenced by the notes of others. And so I would say to you that notes are not entitled to any greater weight than each juror's memory of the evidence that's being presented. In just a few moments, we're going to begin opening statements, but I want to, before I do that, I just want to ask the same question that I asked at the beginning of voir dire yesterday. During the last 24 hours, has anyone that's a member of this jury been exposed to any media coverage of this case, either through any TV newscast or newspaper article, blog, email, or any other type of source? Has anyone on the jury been exposed inadvertently to any media coverage over the past 24 hours? Okay. Let the record reflect that there was no affirmative indication that anyone had been exposed to any jury coverage. All right, so at this time, the attorneys for the parties are going to have an opportunity to make their opening statements, as indicated, in which they may explain to you the issues in the case and summarize the facts that they expect the evidence will show. After all the evidence has been received, the attorneys will again have an opportunity to address you and make their final arguments. Again, the statements that the attorneys now make and the arguments that they may later make are not to be considered by you as evidence, but you should not read that as that you shouldn't pay close attention, because their opening statements are very, very important in terms of telling you what they intend to proceed with and present. So I do ask that you listen to them very carefully and give them your very close attention. At this time, is the state ready to present its opening arguments? All right, you may proceed, Ms. Coakley.
Morning, everyone. Over the course of this week, you're going to hear a lot and get to know a lot about the life of, he goes by, and today he is 16 years old. But this case starts, and really the focus of what his life was like is how his life was in end of December 2021 and January of 2022 when he was just 14 years old. This morning, you're going to learn that on January 28th, 2022, he ran away from home. He lived in Jupiter, Florida at that time with his parents, the defendant, Tim Ferriter, and his mom, Tracy Ferriter. You're going to hear that was adopted as a child, as a small child, a toddler age from Vietnam, and he had lived with the Ferriters since that time. He was the second of their 4 children. He has an older sister named, who you're also going to get to hear from at this during this trial, a younger sister named, and a much younger little brother named, who was about 3 years old when all of this happened. And in January of 2022, he was a student at Independence Middle School and 14 years old. You're going to hear on the 28th, he ran away from home. He was reported missing to the Jupiter Police Department, and that's where this case starts. You're going to hear from Jupiter Police Department officers who are going to tell you that they took the report of a missing child and that he didn't come home on the next day on the 29th, and he also still was not located on the 30th. They went back to the Ferriter residence to find out if there was new information. Had he come home? Was there any leads? The day he left was a Friday, still wasn't there on Saturday. And on Sunday, Detective Sharp from the Jupiter Police Department went into the Ferriter home with Tracy Ferriter. You're going to hear it's at that point that for the very first time, he learned about how he was living, about what his living situation was like at home with his parents. He's going to tell you that he was shown the house, and the first thing that stood out to him was that the child who they were looking for didn't have a place to sleep in the main house. There wasn't a bedroom for him. There weren't his items of clothes. There weren't his toys inside of the house. Instead, there was a structure, a small room box-like structure that was constructed in the garage that didn't have any windows. It had a box spring and a mattress, a bucket in the corner, and a desk. You're going to hear that at that point, the child still wasn't found, and so Detective Sharp left and continued the investigation. And the next day, which is Monday, January 31st, shows up at his school. And there he is made secure, made safe by the Jupiter Police Department. And that's when the criminal investigation really starts, after they had the opportunity to speak to him. You're going to hear that as part of the investigation, during that initial walkthrough of the room, Detective Sharp realized that that small cell-like room had a ring camera in the corner to observe the occupant of the room. And so as part of his investigation, he served a search warrant to the Ring Corporation to see if they had maintained any videos. And you're going to get the opportunity to see and hear that evidence that was returned from the Ring Corporation, because that Ring camera captured moment after moment of life in that room. You're going to hear over and over and over again that door locking and unlocking, because the evidence is going to show that that room was not a room that could come and go from as he pleased. He was locked inside from the outside over and over again. You're also going to see that he did not have the ability to control things like the lights in that room, that the only way that those lights could be controlled was outside the room. And so you're going to see him sitting in the dark in a windowless room for hours at a time. And we're not just talking from 10 p.m. till 7 o'clock in the morning overnight. You're going to see that even during the day, there are times in which his parents, the defendant and his wife, would turn off that light and leave their 14-year-old son locked in a room in the dark, alone, isolated. You're also going to get to observe and hear the anger and the derision, the physical altercations that this defendant has with his child on the Ring camera, physical intimidation, and the threats of violence. You're also going to see having to use that bucket, having to pee in the bucket, because for hours overnight, he did not have access or the opportunity to go to the bathroom. And the only option for him was to pee in the bucket. And then you're going to see the next morning when that occurred, that this defendant would tell him, clean out the bucket, make sure the neighbors don't see you doing that. because this treatment, his life, was kind of a secret thing. And you're going to hear that it's not the state's case, and it's not the evidence in this case that he was kept in there 24 hours a day. He went to school. There were times where he was outside of the room with his family. There was times where he was shoveling shells for his father for hours at a time. But for long periods of time, for mass majority of this child's life, in that period in Jupiter, Florida, he's in that room, isolated, alone, without autonomy, without privacy, without stimulation, sometimes with only a single book to read over and over again. As part of the evidence in this case, you're going to hear that the defendants are charged with that 4-week period, that 4 to 6 week period, because the family moved to Jupiter, Florida in December of 2021, mid-December, kind of a week or two before Christmas. And this all happens at the end of January. So we're talking about 6 weeks when they are in Palm Beach County, Florida. And so that's the charge time period. That's the criminal conduct that we're talking about. But the state expects that you're going to hear evidence about Ronan's life before the family moved to Florida, when they lived in Arizona. We expect that you're going to hear testimony about a very similar, nearly identical room that the family constructed for him in Arizona, in which he had been residing in since he was 11 years old. You're going to hear that that room had no access to a bathroom, no control of the lights, no freedom of movement, that he was recorded, and that he was locked in from the outside with only a bucket to go to the bathroom. The charges in this case are aggravated child abuse, child neglect, and false imprisonment. And at the end of this trial, Judge Coates is going to read you instructions about what the law is for child abuse in the state of Florida. And you're going to hear that there's child abuse and there's aggravated child abuse. Aggravated child abuse occurs when a defendant engages in malicious punishment of a child, willful torture, or the willful caging of a child. And those are in the alternative, meaning it could be any of them. And child abuse in the state of Florida means the intentional act that causes physical or mental harm, or conduct that is likely to cause physical or mental harm. So that doesn't mean that there actually has to be harm. It's just that it's likely to cause harm, that they engaged in an act that is likely to harm a child. And to help you understand what the harm is here and how this conduct is criminal, the state is going to call a Dr. Wade Meyer. Dr. Meyer is a child psychiatrist. He's affiliated with Brown University, and he's going to tell you the impact that this kind of treatment has on a child, that it's humiliating, isolating, cruel, and malicious. He's going to tell you that it will cause harm to any child, but it will certainly cause harm. That harm could be exacerbated if that child already has a behavioral issue or has trauma. And you're going to hear about some of that in this case. It's true, and we'll admit that there are times that he did not follow the rules, that he made mistakes, and that he did things that his parents punished him for. But you're going to hear that in no circumstance is this a protective punishment for any child. And in particular, for a child who may have issues with trauma or a behavioral issue, that this is the worst possible thing that a parent could do. It is the exact opposite of any recommended treatment, of any therapeutic purpose, or anything that would lead to productive response from a child. Instead, Dr. Myers would tell you that it would increase the likelihood of behavioral issues. Because when you isolate a child like this, when you humiliate them, when you basically put them in solitary confinement for large portions of the day, that has a negative mental impact. At the end of this trial, Judge Coates will instruct you on the law, but I want to be very clear on a couple of things. The state here does not have to prove that every moment of its day they were committing a crime against her. We don't have to prove that there are no moments when he was let out of the room. That's not the state's case, and that's not what Dr. Myers is going to say is necessary to cause harm. We also don't have to prove, and you're not going to hear, that there's any kind of legal defense or special standard for a child that has behavioral issues. That if
Overruled.
the law, you're going to hear from Judge Coates. The law you're going to hear from Judge Coates is not going to be that there's any kind of affirmative defense or that there's any different standard just because a child has behavioral issues. We're here today because of the actions of Tim Ferriter towards his son. They were ongoing, they were intentional, and they were criminal. And so at the end of this trial, after you have heard all of the evidence, all of the testimony and the law from Judge Coates, we're going to ask you for the only verdict that is supported by the evidence and the law. And that's a verdict of guilty as charged. Thank you.
All right, thank you, Ms. Coakley. Is defense ready for an opening? Ms. Murad, you're going to handle it? You may proceed.
Thank you, Your Honor. It is a parent's responsibility to make tough choices. Tough choices to protect their child, tough choices to protect their other children, and tough choices to protect the community. And that is what Tim Ferriter did. He was faced with an impossible situation. And he made tough choices to protect what we will call him throughout this trial from himself, from the other children in his home, and from the community. You only have to make one determination in this case, and that is whether or not Tim Ferriter had the criminal intent necessary. That's it. Did he or did he not have the criminal intent? And that will be your guiding question throughout this case. This case is not about whether or not Tim Ferriter made the right choice, because I will be the first to tell you, the defense will be the first to tell you that he did not. But what it is about is the difficulty of parenting, right? Because bad parenting does not make somebody a criminal. Bad parenting does not mean that a person should be charged with a crime. It makes them human. It makes them a parent who is trying to figure out, when faced with a child, as you'll hear throughout the trial, who has consistent and escalating behavioral issues, how to handle them. You will learn more throughout the trial, but I want to try in these next few minutes to share with you what that relationship looked like. In 2009, Tim Ferriter and his wife Tracy took the very long flight to Vietnam to adopt their first son. At that point, him and his wife Tracy had spent some time in the Honduras, and so they were really motivated to adopt. And the first child that they adopted, you will hear from in this trial, is Chinese. And after they were really excited to adopt again. And they wanted her to have a sibling that was culturally close to her. While they were waiting to get the news that they were going to be able to adopt from Vietnam, they had their first biological child. And within just a few years, they go from this young couple to a little family. They have 3 little babies. And this is really the first iteration of that family before it comes along several years later. Tim and Tracy love these children.
Objection, Your Honor.
Overruled.
They did everything that they could when they were young. Karate, softball, soccer. I was in track. He loved Legos. They got him science posters and galaxies. So he had a periodic table of elements and stuff about galaxies in his room because those were his interests. But what we don't know is how our stories will be written. We don't know where our children are going to end up. And as parents, all you can do is try to raise children who make good choices, who are going to be productive members of the community, and hope that that works. And it, unfortunately, it just couldn't. Later in this week, you will hear from a seasoned psychologist, Dr. Sheila Rappa. Dr. Rappa is well respected as a forensic psychologist. She's routinely hired by the state attorney's office. She is routinely court appointed to conduct psychological evaluations in this county, to give opinions about psychiatric or psychological expertise. And her specific experience is working with children like. And so that's what makes her uniquely qualified to speak with you about the records that she's reviewed and the patterns of behavior that she noticed. Underwent a neurological examination. And what it shows, and as Dr. Rappa will explain to you, is that neuropsychological evaluation showed elevated levels of a lack of inhibition and clinically elevated levels of a lack of emotional regulation. And as Dr. Rappa will explain to you, these elevated levels are associated with early life brain development, usually when someone's a baby, pre-verbal, or even in utero. And that makes sense because Dr. Rappa reviewed records, early childhood records and what they show is that he had malnourishment, he was not well taken care of when he was dropped off at the orphanage and while he was there. We can't know his exact medical history because his biological mother just left him at the orphanage, but the records that Dr. Rappa has reviewed over the course of life, in addition to some of the depositions taken in this case, other records, they will show you that, for very much lack of a better term, is wired this way. It is a function of brain development. And it's why the Ferriters continued to see patterns of behavior that would not stop. I want to take you through some of those patterns. Since he was a kid and had aggressive outbursts and tantrums.
Overruled for purposes of opening.
His parents regularly received emails of him fighting at school, punching other kids, using profanity. Tim and Tracy moved. Well, let me start with this. He was at a school with his sister where he pretended that a teacher asked him to make an announcement in class. So he was in a different class. He goes into class and says, oh, the teacher asked me to make an announcement. He has his sister stand up and humiliates her in front of the entire class, saying that she's a horrible person. And it was so disturbing to the teacher who was present, who you'll hear from throughout this trial, that she had to report it. Tim and Tracy moved into an accelerated private school in hopes that the challenging work would engage him. It was sort of a math and science type school, so they thought that that would help him stop. It did not. He stood up in class at that school and asked if the Holocaust was a good thing. He was accused of telling a student that they should get aborted. He got up in class and said that immigrants are more likely to be drug dealers. He brought a screwdriver to class and was waving it in someone's face. He stole another student's laptop, hacked into it, and looked up women getting run over by trains.
Sustained.
And he pretended to be a tutor to a friend of his.
Sustained.
And that happened while he was in
Counsel approach.
I didn't think it was going to take this long because they usually have the breaks cut out. Thank you for bringing awareness to those who might not otherwise hear their cries. This is going to be a really sad trial, you guys. Just be prepared. So I'm going to say I was just reading the
All right,
story.
Ms. Murad, you may continue.
Also pretended to be a tutor to one of his friends and then stole her father's credit card and utilized it.
Overruled as to that.
Thank you, Judge. This is just a handful of the consistent and escalating behaviors we continue to engage in. And he himself will tell you, as the state said in their opening, that he knows that things are wrong and he continues to do them. He knows that there are consequences and he continues to do them. And all this time, Tim and Tracy are racking their brains trying to figure out what will change behaviors because they have an entire family here, right? These kids go to school, they have their own activities, they have a toddler at one point. They have to be able to get through the day-to-day of just being an adult and having a family, be able to send their child to school safely, knowing that other children will remain safe. So they try to get him into activities to kind of take out his energy. And when they see that's not working, they do counseling. They give him the medications that he's prescribed. They try to help him sleep at night because he keeps wandering the house. They cut sugar from his diet on the recommendation of a pediatrician that maybe that'll help his behavior and that'll make him less impulsive. This family is going from place to place to place, from appointment to appointment, trying to figure out how to get this child actual help, how to get a diagnosis, and how to get medication that will change his behavior. And as we discussed in voir dire together, what they found was a revolving door of doctors and therapists, and no one was able to offer them the help that they needed. You will see that Tim tried to curtail behavior when nothing else worked, and there will be some videos of that. It's not always going to look pretty, just as it doesn't look pretty in real life when a parent gets mad at their kid. Particularly a child, and you must remember when you see the videos, particularly a child who for years and years and years is continuing to engage in these behaviors, who will not stop. In 2019, while living in Havasu, Arizona, Tracy and Tim had their last and youngest child. And at that point, they are fearful. Are a little bit older. They're about 10, 11 years old. And this is coming in as an infant. And at this point, he had been hurting other kids at school. He had been engaging in dangerous behaviors. He's walking around at night. And they did not know if an infant could be safe within in the house. And that is when they made the decision, while he lived inside their home in Arizona, this is not in the garage, this is in a house, to put a lock on his door. And that was not for the purpose of keeping him locked inside at all times. It was not for the purpose of even punishment. It was for the purpose of monitoring him when they couldn't. Because unfortunately, they're in a situation where they cannot leave this child unattended. There has to be somebody constantly watching him, and they cannot do that as two working adults. You'll hear that Ray participated in activities. He went to school. You'll see videos of him around the house, and he will tell you himself that the door was not always locked. But they did use it when he couldn't be supervised. Once he was born, they needed a baby room. So they built a room in the Arizona house in the garage. It had a bed, it had a desk, it had Legos. You'll hear from witnesses who actually saw that room and showed it to them. Took them in and said, hey, look at my room, and showed them all the toys that he had and the books that he had in the room in Arizona. So right before Christmas of 2021, that's when we get to sort of the time relevant in this case. The Ferriters moved back to Jupiter, where they lived many, many years ago when the kids were young. And they decided to build a similar room for. It had the bed, desk, books, and toys. You'll see videos of him in his room. He's reading. He's talking to his friends. He has Legos there. He is not allowed to have technology in his room alone because that's not something that they felt was safe, but he had other types of activities. He did have like a school Chromebook that was provided by the school. You'll see him FaceTiming with a friend of his. He had posters up on the wall that he, you know, when he got angry, ripped down himself. That's why the walls will look bare. Both the room in Arizona and the one in Florida had one very big design flaw, and that is that it did not include a bathroom. And this means that at night when he was in the room and couldn't be supervised, had to use a bucket for the bathroom if he needed to use the bathroom. During the day, he was permitted to move about the house freely, and he could utilize the bathroom in the house itself. And I'm going to be very honest with you. You're going to see him use the bathroom in that bucket a handful of times over this 4 to 5 week period. He's a kid, so he's not waking up and using the bathroom all the time like probably all of us are. And so he uses it a few times, and it's not going to look pretty. But what you have to remember throughout this case, right, is that this was not some big secret life like the state is presenting. These people went to doctors. They went to therapists. The schools were emailing them back and forth about his behavior. They had family members and friends see the room in Arizona. In Florida, they were only here for about 4 weeks right before Christmas, and then school started. So this is not some sort of secret life that they had for. Everybody knew that had behavioral issues. Everybody knew that Tim and Tracy were trying to get a diagnosis so that he could get appropriate help, and it never happened. As you review the evidence in this case, you have to remember that the issue at hand is not whether or not Tim Ferriter is a great dad. It is not whether Tim Ferriter did what you would have done, and it's not even if Tim Ferriter did the right thing, because our own expert, Dr. Rappa, will say that he did not, and that those actions could have been damaging to the child. That does not make his actions a crime. The singular question in this case is whether or not there was criminal intent. Because what Tim did not do is have his child arrested. Not one time. What he did not do is undergo a failed adoption proceeding where you essentially return a child back to the Department of Children and Families.
Sustained.
He paid.
Sustained.
Okay.
No need to approach. I sustain the objection.
He paid for private schools so that he could have activities that he was engaged in. But he had to make tough choices to protect his son, to protect the other kids in his home, and to protect the community from a child who was already showing, a screwdriver in class, hitting other kids. He had to do that. And though he didn't handle it correctly, his intentions were not criminal. Dr. Rappa will testify, based on her extensive experience and review of the records, that what she sees in this case is not malicious. That what she sees in this case is actually very common for parents with children who have such extensive behavioral issues that are hard to sort of diagnose and pinpoint. At the end of this trial, I'm going to come back up here, after which I expect to be about a week. And I'm going to ask that you really listen to what he says, even in his own testimony. And that you consider what it's like, and that you consider how a parent
Sustained.
How a parent has to act in these situations. The difficulty that Tim Ferriter experienced over and over and over again. The help that he attempted to give his child over and over and over again. I'm going to ask that you find him out.
All right, thank you, Ms. Murad. Ms. Coakley, stay ready to call its first witness. You're doing the direct, Ms. Black?
Your Honor.
Okay.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Ms. Black, you may begin at your convenience.
Good morning.
Good morning.
Please state your name for the record, spelling your last name.
Officer Ryan Kolenich, Kolenich,
Where do you work?
the town of Jupiter,
How long have you worked there?
approximately 8.5 years.
And what's your role?
Patrol.
Okay, patrol what?
Patrol officer.
Okay. How long have you been doing that?
The entirety of my 8.5 years.
Okay. And do you have any prior law enforcement experience?
I do.
Where?
As a patrol officer in the state of Ohio,
How long did you do that for?
approximately 5 years.
Now, as your role now, what kind of training and experience do you have?
I am a field training officer and I'm on the emergency field force team.
And what do you do as a field training officer?
I oversee and guide new officers.
Now, every year, do you have to do any continuing education?
Yes, every year I complete my required annual training with the police department.
Now, I'm going to turn your attention to January 28th of 2022. Do you remember that day?
I do.
And were you working that day?
Yes.
What was your capacity that day?
Road patrol.
Now, where did you first respond?
For like the address,
Yes.
we went to an address in Egret Landing, I believe.
Is that in Jupiter, Florida?
Yes,
In Palm Beach County?
it is.
Now, what were you responding in reference to?
A missing juvenile.
Who did you make contact with when you first arrived?
The missing juvenile's mother.
And what was her name?
I believe it was Tracy.
Okay. Now, at this point, when you arrive, are you with anybody else?
Myself, I was with my training officer, Officer Picard, but no, just Tracy herself.
And you guys arrived there via patrol car?
Correct.
When you first get there, what do you do?
Made contact with the mother at the home.
And where did you make contact with her? Did you ever go inside?
No.
So you had a conversation with her outside that house.
Yes.
What was the point of having that conversation with her?
Fact finding, information gathering, so I could relay the information that I was given to responding officers to check for the missing juvenile.
Now, did she ever give a description of that juvenile?
Overruled.
Did she give you a description?
Yes, I believe so. Yes.
And what was done with that description?
We relay that information over the air to officers that are checking the area for the missing juvenile. And it's later typically used for like a BOLO of some nature to put out to other surrounding agencies.
Okay, so you mentioned BOLO. What is BOLO?
It's just like a memo or a transmission to be on the lookout for a certain item, whether it be a person, vehicle, property of some nature that's sent to officers, not only on my shift that I work with and other surrounding agencies.
Now, when you spoke to the mother, how is her demeanor like?
You'd have to ask me. I'm not sure what kind of answer you're looking for. It just she wanted to locate her child, I guess. I'm not sure as far as the demeanor. I don't know.
Okay. Did you ever make contact with the father, Mr. Ferriter?
No.
Now, after speaking with Ms. Ferriter, did you go to any other location?
I personally did not. Other officers did.
Okay. And do you know where the other officers had gone?
Yeah, they went to check surrounding areas, I believe that she relayed to me as far as like a local church, local parks, and just major thoroughfares throughout the town.
So at the end of January 28th, 2022, did you ever locate that child?
I did not.
1 minute, Your Honor.
All right, cross-examination, Mr. Wahid.
Morning.
It was Tracy Ferriter who called the police, correct?
Correct.
And your the efforts that JPD made thereafter were essentially looking for a runaway child, correct?
I can't speak to thereafter. I'm not. I don't know what happened thereafter. As far as just on scene with myself is all I can. That's all I can explain to you.
Correct. So, based upon the information you received the day you met with Tracy Ferriter, you essentially began a search for a child, correct?
Yes.
Who had run away from home, correct?
Yes.
And you were provided with possible places he may have gone, correct?
Yes.
And you mentioned a church, correct?
Yes.
You also mentioned local parks, correct?
Yes.
And you weren't involved with actually searching any of those locations yourself, correct?
Correct.
Okay. One moment. Nothing else. Thank you.
Thank you, Mr. Wahid. Any redirect, Ms. Black? No redirect, Your Honor. All right, is this witness excused?
Yes.
All right, sir, that concludes your testimony. You may step down. Thank you for being here. State, call your next witness.
At this time, the state would call officer, actually, it's Miss Collins right now. Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Ms. Black, you may begin at your convenience.
Good morning, Ms. Collins. How are you?
good morning. I'm well. How are you?
Could you please state your name for the record, spelling your last name?
Sally Collins, Collins.
Where do you currently work?
I work for a law firm in Port St. Lucie, St. Clair Law Offices.
What do you do there?
I'm a bookkeeper.
Now, back in January of 2022, did you have a different occupation?
I did.
Where did you work then?
I was a police officer for the Jupiter Police Department.
How long were you a police officer?
19 and a half years.
Now, during those 19 and a half years, did you stay in the same role?
Yes.
And what was
most
that?
of the time. For about 6 years, I did recruiting and background investigation, new hire officers. For the rest of my time, I was road patrol.
Now, did you have any prior law enforcement experience?
No, ma'am.
And what kind of training and experience did you have as a road patrol officer?
I did the initial 6-month academy at Palm Beach Community. It was Palm Beach Community College now. It's Palm Beach State College. And after that, I did our in-house training. I took different interviewing techniques and all those kind of basic courses that we do throughout our careers, in-house and at other locations.
So I'm going to turn your attention to January 29th of 2022.
Yes, ma'am.
Were you working that day?
Yes, ma'am.
And in what capacity were you working?
I was working road patrol and I was assigned to District 2.
And was anybody with you?
Officer Chad Smith was also assigned to District 2.
Now, at any point during that day, did you become aware about a missing juvenile investigation? Would looking at your report refresh your recollection?
Yeah, would you mind if I looked at my report? And you said January 29th?
Yes.
Okay. Sorry, gotta get readers. On the 29th, my sergeant had said that there had been a report of a missing juvenile taken the night prior, so I guess the 28th?
Yes.
And so on the 29th, I believe he said something to the effect of, it's a teenager that went missing, reported by the school as missing. If you could follow up with the parents and see if he's returned home. You might want to wait until later in the day to see if he's gone to school and has come home after school, something like that.
Okay. So at this point, it is January 29th of 2022.
Correct.
Okay. And after receiving this information, what do you do with that?
I'm referring to my notes here on the call. I initiated a call. Normally what we do when we're called for service is there's a call generated. If it's something that we decide we're going to go and do on our own, we can pull an event number and then tag that to the location and put our notes in that, what we did.
So at this point, who are you trying to make contact with?
I was trying to make contact with either Mr. or Mrs. Ferriter.
Okay. And did you eventually make contact with either of them?
I made contact with Tracy.
Okay.
And my note says she advised that one has not yet returned and she would call the police department with any updates. And my note says, but she didn't seem overly concerned as he's done this before.
Okay. Now, is it typical for you to follow up when children are missing?
Yes.
Okay. And how often would you do something like that?
Road patrol is sometimes very responsive. And so if you're going call to call to call, it might wait a few hours, or it might be something that you accomplish first thing when you get to work is to follow up with something.
Did you ever hear back from Ms. Ferriter on the 29th?
The next day, when I reported for duty, my shift started at 5:30 in the morning.
And I'm sorry to interrupt, but we're now talking about January 30th of 2022.
Correct.
Okay. So what did you do that day?
That was a Saturday. And so my sergeant had said, hey, night shift didn't report that he came back. So at some point, can you go to the house or check in with them again and see what the status is and see whether this child is returned.
Okay. So at that point, what do you do?
So I spoke with Officer Smith, who is routinely assigned to District 2. And I said, hey, I want to go out to the house and see if we can get a hold of them because it's being a Saturday morning. Maybe he's returned. Maybe they've heard from him, something. Let's just go to the house.
Now, when you went to the house, did you notice any cars in the driveway?
I don't believe there were any cars in the driveway. We looked at the property. It didn't look like anybody was home. It was quiet. We did knock at the door several times. Again, it was quiet, didn't appear to be anybody home. There was a chain link fence that ran down the side of the property. We kind of looked over that to see if we could see any movement, see anybody home. It's not unusual that people keep their cars in their garage. And so we didn't know if anybody was home. Repeated knocking, walking around the house, nobody came out.
Okay. So at that point, you notice that nobody's answering the door. What is your next step?
So again, I said, well, let's call her. Because I spoke to her yesterday. Let me call her again and see if we find anything out, see if he's returned home or, maybe they just haven't told us yet that he's back.
And did she let you know that he had not returned home?
Yeah. So I placed a call to her and I actually, my body worn camera had been activated while we were out there. And because sorry, this is a little backstory, but we don't get assigned cell phones. So we have to use our personal cell phones. I don't like to use my personal cell phone to call people I don't know because then they'd have my number. So I called dispatch and said, can you put me on a recorded line and can you record the conversation? Can you patch me through to her? So I gave dispatch her phone number. They called her and she answered that phone call.
Now, without going into details of the actual phone call with her, did she let you know that he had not been found yet?
That's correct.
Okay. And did after you were at that residence, after you spoke with her, what else did you do?
So while I spoke with her, seemed to be a normal conversation. I was asking, would they be home? Where were they? Are they coming home soon? She indicated that her husband was with one daughter at some sporting events in Jupiter, and that she was with their daughter at Jupiter High School for band practice or something to do with the band, and that it wasn't convenient for them to come home.
Now, did you ever at any point go to the house later that day?
No.
Your Honor, what minute?
Granted.
No further questions.
All right, Cross.
Yeah, you said that you were told that the husband was in Florida at the baseball game on that day. This is on the 29th?
The 30th.
The 30th.
Yeah, which was
Okay.
a Saturday.
Do you know subsequently that that's incorrect, that he was in fact in Ireland during this entire time?
No.
Okay, so that was information that you noted it somewhere? Did you write that down?
It's written down that made contact with Tracy and she advised nobody is home. One daughter is at Jupiter High School with band and one at JCC with sports.
Okay, so nowhere in there does it say that Tim Ferriter is with any of the children in Florida on that day, correct? It does not say that.
It does not say that.
Okay, so it's possible you're incorrect when you testified that Tim Ferriter was in fact with a child that day in Florida, correct?
Could you repeat that?
It's very possible because you said on direct that Tim Ferriter was told by you, sorry, Tracy Ferriter told you that Tim Ferriter was with one of the children that day at a softball game. And your notes don't reflect that. In fact, do they? There's nothing in your notes that say that.
Softball, it said sports. I also haven't had a chance. I retired from the Jupiter Police Department in February, a month after this event. I haven't had a chance to review my body-worn camera, so I can't tell you as I sit here whether she specifically said she's at the game with her father or not. But at no point did anybody say to me, he's in Ireland, he's not in the country.
Is it very possible that Tracy Ferriter did not tell you that Tim Ferriter was with any of the children that day?
Without listening to my BWC and reading what's here, it's possible.
May I take a quick look at that note you're looking at?
You can approach.
I was reading from one daughter at JHS with band and one at JCC with sports.
Okay. So just so I'm clear.
Counsel, you need to, if you're going to speak, you need, you have to be at a mic or you won't get picked up.
I also need my reading glasses. One minute. Sign the page.
Yes, sir.
Nowhere on this report, though, does it say that Tim Ferriter is with the child. It says where one child is and where the other child is. It doesn't say the father is with any of the children.
You're correct.
Okay. So when you're saying that Tracy Ferriter is telling you that Tim Ferriter is with one of the children, that isn't in your notes.
You're correct.
Okay. I have no other questions.
Any redirect? Is this witness excused? right, ma'am, that concludes your testimony. You may step down. Thank you for being here. All right, state, call your next witness. You can approach. All right, so ladies and gentlemen, at this time, it's about noontime, so we're going to go ahead and break for lunch. I usually try to go to 1:30, but because of logistics with some witnesses, it'll be between 12 and 12:30, as I told you. In any event, we're going to break for lunch now. Today, I'm going to give you a little bit longer than you should probably expect throughout the remainder of the week. You'll have from now until 1:25. I want you meeting with Mark out at the elevators at 1:25 for a 1:30 sharp start time on the afternoon session. Remember, and I know I'll say this to you until you're sick of hearing it, during the break of the recess, make sure you don't discuss the case with each other or with anyone else. Do any kind of research or investigation. And also, as I've said before, make sure you're not inadvertently exposed to any type of media exposure to this case. Other than that, have lunch, relax, and I'll see you back in about an hour and a half. All right, everyone may be seated. Court will be in recess until 1:30.
The Honorable Judge Howard Coates presiding.
Good afternoon, everyone. You may be seated. All right, we're back in session on State versus Ferriter. All sides ready to proceed?
No, I think this is going to help me turn that, like, how to turn it back on to make it so we can,
The TV?
yeah, is it,
Pushing the power button, I presume.
try that.
While he's looking at that, we do need, in order to preserve the record with respect to the video that was requested by the defense in the opening statement, I'd like you to take that video, put it on a thumb drive, have it marked as Defendant's Exhibit 1 for ID purposes, so that it can be properly made a part of the record, because we didn't do that at the opening, but let's make sure that's taken care of.
Just want some objections. Defense, I'm going to show them the video we're going to play through this witness, but the defense has indicated that there's a video that they intend to cross-examine him on, and I would take an objection to it.
Okay, so we didn't address it in by way of a motion in limine, so I'm going to address it in real time as it comes up at the appropriate time in the cross-examination at this point.
They just let us know about it.
Okay, no, I understand. So I'll handle that the same as I would any other evidentiary objection. All right, Mark, have we figured that out?
Well, so ours, we addressed and we reserved, Your Honor, as this is the time when we would like to put in the evidence of the actions of Tracy Ferriter changing the room. So this witness that's about to testify, we have an objection separately that wasn't addressed before because we weren't aware of it, to the videos that they want to use during cross-examination of this witness.
Okay.
In the motion in limine, though, we did address two of the videos that the state would like to enter here. So this witness is going to testify that he entered the Ferriter's home prior to the child and took a look at the room. And that's when the room was first discovered. This is the lead detective, Detective Sharp. When we did the search warrant of the Ring camera, it was revealed that immediately before Detective Sharp is led into the room and sees the room, that Tracy Ferriter goes into the room, takes out some of the sheets, and then also takes out the bucket.
And this is the state's video.
These are the state's videos. They're from the Ring camera, but yes, they're the state's videos. And
Okay.
so we think that this is necessary evidence in order to show why when subsequent, like here, when he views the room, it's different. So he's not aware of the bucket or any of that because of her actions. There's no statements. And then subsequent to that, there's a search warrant about 8 days later, and the room is substantially different at this time. The defense alleged that they don't want it to be attributed to Tim that these actions happen. We're not eliciting any statements. It's actions that are caught on video. Beyond that, they're charged as co-defendants and they're principals to each other's actions. So if this was a bank robbery and Tracy Ferriter, during her escape, took actions that we had video of, those would be admissible in the state proving our case, because they're charged because of the principal theory. They're charged as principals to each other as co-defendants, and they're responsible for each other's actions that are in furtherance of the crime.
Right.
And so there's 3 videos total that we're going to play. The first 2 are.
Let me stop you there. This is the argument that I heard in limine, and this is one that I said I'd reserve until time of trial. You have any additional argument other than what was made in limine at this point?
Not any additional argument to that. One video doesn't involve, so there's 3 videos total. I believe the objection is only to 2 of them, which are Tracy taking the actions to change the room before law enforcement gets in. We're also going to show.
And you're not playing the audio, you're just.
There's no audio to those 2. There's a 3rd video where Detective Sharp goes in and she kind of shows him the room, and he looks around and you can see him like noticing as part of his investigation some of the aspects. She does say some things during that. We are going to play that one without audio.
Okay, all right. So let me hear Mr. Wahid. You're standing there, so I assume you're going to make the argument on this issue. Okay.
So while I wasn't at the motion in limine, I'm looking at it. So the issue, first of all, the state's argument that it's an act in furtherance, it's actually not. So under co-conspirator law, when the crime is done, anything subsequent to the crime, which is, cleaning up or hiding the crime or all of that, is not considered part of a crime. Therefore, it's not in furtherance, according to federal case law at the very least. And I'm not quite sure.
You have any state case law that supports that position?
I haven't looked at that, so I can look that up, but this is something I do know.
Well, now's the time. If you have it, I need it now because I'm going to be making a ruling imminently.
All right. Well, I'll need a moment then, Judge.
Well, you're not going to get it. You got to make it now, and I'm going to make a ruling because we are in the middle of trial and they need to proceed. I understand, but everybody's been aware of this issue and should come well prepared to argue any evidentiary or legal points with any citation to case law that exists. If you don't have it for me now, day late and a dollar short. I need to make a ruling. So go ahead, Mr. Wahid. And you certainly can rely on your federal case law that you've got. I mean, I'm not saying I'll discount that altogether, but I certainly like to hear state case law when it comes to state evidentiary issues.
Of course, understood. And then the other argument, Judge, here is that there is zero evidence that Mr. Ferriter had any idea about any of this that was going on, in that while it's not in evidence, at some point it might be in evidence, is that he wasn't even in the country at the time. And the court severed this case for a reason, is that you don't want the jury to take admissions of possible consciousness of guilt of one party and impute them on the other. I think that really muddies up the water here, and quite frankly, I think it counters why the court agreed to sever in the first place. So I don't know that this is in terms of admissibility. Those are my arguments. Obviously, I also think there's a 403 argument, which is this is substantially more prejudicial than it is of any sort of probative nature of Mr. Ferriter's culpability.
Okay, thank you. Brief rebuttal, Ms. Coakley, and focus on your argument again with the principal point that you're making.
Right, they're charged as principals to each other, so their culpability is intertwined as principals. So the actions that were taken in furtherance of the criminal act of one can be attributable to the other.
And you have 3 videos, 2 of them of which have no audio, and a third one you're playing without audio.
Yes, the first 2 are just her removing things from the room. She removes some blankets, and then she removes the bucket, and then immediately after that, chronologically, is when the detective is shown the room. That's when they have that one. I don't believe that they're objecting to. And he looks around, sees the room, there's talking. We're not going to play the audio for that one. The first two don't have audio, I don't believe.
All right, the defense objection to the playing of the 3 requested state videos is overruled. So they will be permitted to be played during the testimony of this witness. Now, is there another video that I need to address that the defense?
The
is gonna be
defense has
playing-
let us know that they're going to try and bring in some body cam. Depending on what they bring in, I'll let Ms. Black make a contemporaneous objection. We may not. We can.
Body cam of the,
It's not of this witness. It's a body cam from the search warrant.
but
And
of the structure?
of the house, yeah. And so I think it might include. So I don't know what they're intending to try and offer. Depending on that, we can make an objection at that time. The second one they have indicated to me is that when the child was found at Independence Middle School, he was initially placed in handcuffs and taken into police custody, like they caught him. They want to put in body cam of the child in handcuffs. The state would object to that. It's not relevant. It's prejudicial, and it can cause a confusion of the issues.
Okay, so.
They have indicated that the reason for that is they want to show how he looked at that time. Immediately after he was caught, he was taken to the Jupiter Police Department. There was a recorded interview where he's on video, and there's also photographs of how he appeared at that time taken for that purpose. There's no reason that they have to show him in handcuffs other than to insinuate that there's some kind of criminal conduct there, which Your Honor has already ruled was not admissible.
Okay, Mr. Wahid, are you going to be attempting to put this in through this witness? Or is it for some subsequent?
The other issue still, Judge. So yes, I will answer your question, then I will come back to this. I'm sorry, Judge, say that again.
Are you going to be using the video that she is referring to in cross-examination of this witness?
Yes,
All right, so let me hear your argument and then I'll make a ruling.
sure. So the body worn camera of the search warrant, Detective Sharp was present. He's in the video. It does show the layout of the house. It also shows the condition of the house at the time of essentially when this offense all happens, which is, I think the search warrant's executed.
I let the judge know we made a contemporaneous objection
Oh.
to that. We're talking about the one of Ronan being arrested.
Okay, so for the other one, there's allegations that the state is making throughout, that they will be making throughout, that Ronan was malnourished, that he was essentially deprived food. And you see him on this video. This is only a couple of days after he's run away from the Ferriters' home. This is the first time you see him.
All right, so focus on the real issue here. It's not that's not the real issue. The real issue that she's raising is whether it's appropriate to show the jurors the minor being handcuffed by Jupiter Police Department and whether that's unduly prejudicial or probative here.
Well, first of all, the condition of the child is what you're going to see there first. And this is the first time we will encounter the child on video after he runs away. And secondly, it wasn't like there's no allegation in this case that they were arresting him for some crime. They secured him. I don't know why they did what they did, but they secured him and they put him in a car. But that's the first time. That's part of the story of when that's where they get him.
Well, let me just kind of analogize. I don't allow my defendants to come in front of a jury and be handcuffed because of the negative perception that jurors have when they see somebody coming in to the courtroom being handcuffed. And I have a similar concern that if they see a witness being handcuffed, that might have an adverse effect on their determining the credibility or not of that witness. So that's where I'm coming from. So address that concern and why I shouldn't be concerned about that aspect of it. Because obviously, the defendants, we protect them to make sure that they're not handcuffed in front of the jurors precisely to avoid the negative implications of what being handcuffed means.
Understood. Although there have been several videos of interviews of my clients that have come into evidence where they are cuffed to a table. But putting that aside for the moment, in this situation, I don't think there's anything.
I don't think in my courtroom, but at least hopefully not, because I know we typically try to avoid that at all costs. But go ahead.
I don't think there's anything here that is prejudicial to the state at all. I don't think it's not that there is no allegation that we're making that in that moment he was being arrested for some crime.
Let me ask you this. Does the entirety of the video show the minor in cuffs, or is there only a part of it that shows it?
There's a part of it. He walks. I don't know how many seconds or minutes or what it goes. I don't have the timestamp at hand, but he walks down the hall. He walks in. You see him. Then the police officer stops him and then says something to him, and then they put the cuffs on him.
Okay, all right, brief rebuttal, and then I'm going to rule.
It's prejudicial on its face. I wouldn't be able to show the defendants being arrested in this case. There's video of that. They can achieve the same ends. There's video of him literally 15 minutes later at the Jupiter Police Department where he's not handcuffed. And then there's pictures that were taken to document his body. In addition, there's been no allegation, nor will be, that he was malnourished. The defendants were incredibly controlling and limiting about his access to food. That's fundamentally different than an accusation of malnourishment, which is not the case here.
Okay, so my ruling is as follows. The state's objection is sustained in part, overruled in part. It is sustained as to any portions of the video showing the minor in handcuffs. It is overruled as to the remaining part of the video that does not depict the minor to be in handcuffs. So as far as your side, Mr. Wahid, that means you can play the video. You just got to excise out any part showing that the minor is in handcuffs.
I didn't even see that.
Okay, I don't know. That's what
Yeah.
you haven't shown. I haven't seen it.
The video I was trying to show you earlier, it's just him walking down the hallway, and he's in the lobby of the school, and then he talks to some officer, I assume a school resource person, and then they put the cuffs on him. And it might keep going.
Well, what you're describing, I have no problem with, except for the cuffs part that I've already ruled on. But if there is a video of them running the minor down and chasing him and apprehending him, I'm not going to allow that to be played.
I have no intention of playing.
Okay. All right. So
For the record, can I just put a case on the record?
you can put it on the record. I'm not going to change my ruling at this point, but go ahead.
Well, Wells v. State, it's a first district case. We were doing this in a hurry. And it points out that, and in that particular case, it was the homicide case, and that the real issue there was that the questioning, which was after the crime, is not in furtherance of the conspiracy. The crime had already taken place. He's being charged here with aggravated child abuse, that there was no ongoing version of that by the time Detective Sharp has this interaction with Tracy Ferriter. It's therefore not in furtherance of any conspiracy.
Do you have any case law that says that in a co-defendant situation where they're charged as principals to each other, that consciousness of guilt conduct is not something that can be imputed to one of the other principals? Because to me, that's where this becomes potentially relevant, and why I'm ruling the way I am is because if the spouse is showing consciousness of guilt by removing the bucket from the room, and consciousness of guilt can be shown as, that can be the evidence that the state submits. Where you have a principal situation, why would that not be relevant, even under the case you just cited?
Well, the issue goes towards a principal to the crime, and the crime charged here is the actual child abuse charge. That if it would be different if you were.
Well, child abuse, let's not forget false imprisonment and child neglect. And so even on the issue of false imprisonment, it seems to me you've got a much tougher lift to convince me that the consciousness of guilt of one principal isn't imputed or can be used against the other principal. Am I missing something?
Well, I think what the video, as my recollection goes, again, I came into the case late, so if someone correct me if I'm wrong on this, but my recollection is that it is essentially removing some sheets and the bucket. It's not removing the lock from the door, which would be the issue of the false imprisonment. A bucket in a room is not part of the false imprisonment charge. The confinement is the false imprisonment.
Not sure I agree with that, but I understand the point you're making. I'm just not sure I agree with it. I mean, the bucket it could be used by the state as potential evidence of the false imprisonment because it kept him from leaving the room and he had to relieve himself in the bucket. So I can see where they can easily tie that in. Any other argument you wish to make, Mr. Wahid, for the record?
Not unless Ms. Murad comes up with a case very quickly now.
Okay. All right. So my ruling remains the same. Thank you for making the argument, and you put your case on the record.
Thank
Mr. Wahid, thank you. All right. All sides ready to proceed now with the continuation of the state's case.
Yes, we're all set. We did meet during lunch about the next witness, but we are obviously going to need to take a break.
Yeah, we'll take a break. Well, you'll let me know when you're ready for me to take a recess so that we can get the IT set up for the in-camera testimony. And that's the next witness, right? Not this witness, but the next witness. Okay, all right. So Ms. Coakley, you ready to proceed? Ms. Murad? Okay, all right. Mark, you may go ahead and bring the jurors out. All rise.
Jury entering.
All right, everyone may be seated. All right, ladies and gentlemen of the jury, welcome back. I trust everyone had a good lunch and were able to relax during the hour and a half lunch break. In any event, we're ready to start back up for this afternoon. We're still in, as you know, the state's portion of the case where they're calling witnesses. So with that, Ms. Black, is the state prepared to call its next witness? Okay.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mark, can you make sure that's all, it's not in use? All right, Ms. Black, you may proceed.
Good afternoon, Detective. Please state your name, spelling your last name for the record.
Yes, my name's Andrew Sharp, SHARP.
Where do you work?
I work for the Jupiter Police Department.
How long have you been there?
I've been at the Jupiter Police Department approximately 17 years.
And what's your title there?
I'm a detective.
How long have you been a detective?
6 years.
What did you do before that?
Before I was a detective, I had various roles throughout the agency. I was a field training officer. I also worked on a special response team. I had various other roles.
Now, what kind of training and experience do you have as a detective?
As a detective, I have several hours in advanced interviews and interrogations. I also have several hours of training in regards to child abuse investigations, as well as just general investigations.
So at the Jupiter Police Department, do you guys have any specific units, or are you just an overall detective?
We have an overall criminal investigations division.
And as part of that, do you also do any continuing education every year?
Yes, we do.
Now, I'm going to turn your attention to January 30th of 2022. Were you working that day?
Yes, I was.
Okay, and in what capacity were you working?
Yes. So I was the on-call detective for the Jupiter Police Department. So I technically wasn't at work, but I was on call for the day.
On that day, did you get assigned a case?
Yes, I did.
Okay, and what was that?
That day, I was assigned by our Criminal Investigations Division Sergeant a missing persons case.
How do you typically get assigned a case?
So typically what happens when you're on call for the day, anything that comes in that would involve further investigation, it's assigned to a detective. And if you're the detective that's on call, it's your job to handle those investigations.
Once you got that phone call, where did you respond to?
The first thing I did was I responded to the Jupiter Police Department and I made contact with the Criminal Investigations Division Sergeant.
And at that time, are you notified about what's been done so far in the investigation?
Yes, I was made apprised of exactly what took place, that a few nights prior, there was a juvenile that was reported missing. And then there were some other circumstances that led the sergeant to assign it to a detective.
Now, what time did you arrive to the police department?
It was that evening, I would say, without referring directly to my report, probably around 6 or 7 p.m.
And after going to the police department, where's your next stop?
The next stop was at the Ferriter residence.
Did you make contact with anyone from the household prior to going to the residence?
Yes, the Criminal Investigations Division Sergeant and I made a call to the mother in the case, Mrs. Ferriter, just to make sure that she was present at the house before we went.
Now, when you get to the house, what do you do first?
The first thing we did was we attempted to make contact with anyone at the residence. We knocked on the door and we were greeted by Mrs. Ferriter.
Where did you end up speaking to her?
The entire conversation took place outside of the residence, kind of in the front porch area. Right, there's like a brick paver walkway. It was right on that area.
Did you notice anything about how she was acting when you first made contact with her?
Yes. So immediately I wanted to go inside the residence to make sure.
Overruled as to that question and response. You may continue with your answer, sir. You just can't say what someone said,
Sure.
what you did.
Thank you, Your Honor. So immediately I wanted to go inside the residence because I wanted to make sure, find any evidence of where this individual may be and to make sure that his safety and well-being was taken care of. So I attempted to do so. However, Mrs. Ferriter was apprehensive.
Overruled.
And would not initially allow us inside.
Overruled.
You can finish answering the question.
Thank you. We stood outside probably, I think the entirety of my body camera worn footage was about 52 minutes. And I believe 45 minutes was standing outside of the residence, waiting and asking repeatedly to go inside.
Okay. So you said that she was apprehensive about you going inside, right?
That's correct.
And the rest of the time you spent 45 minutes speaking to her outside.
That's correct.
Did you do anything to make her feel more comfortable at that time?
Absolutely. I reassured her over and over that I was not there to investigate her. I was not there for any other reason but the safety and well-being of her son. I said I did not care if there was any kind of other illegal activity going on in the house. I wasn't worried about that. My sole priority was for the missing juvenile.
When you first responded to that house, were you alone?
I was not. I was in the presence of the Criminal Investigations Division Sergeant and Officer Jurak.
Did you eventually go inside the house?
Yes, I did.
Were you the only one that went inside the house?
Yes, I was.
So when you first walk into the house, kind of describe what did you see?
Sure, absolutely. When I first entered the residence, there was a small credenza right alongside the wall there. This credenza, there was an object on it, but that was the only item. Mrs. Ferriter then directed me into a room directly inside the residence. I believe it was to the right. She purported that both of her sons stayed in that room.
Sustained as that the statement, I just refrain from saying what Mrs. Ferriter actually said. You can say what she did, what you observed, but not what she said.
Okay.
So
Thank you, Your Honor.
you indicated that there was a room that you were shown by Miss Ferriter.
That's correct.
Okay. What did you see in that room?
Inside that room, I only saw objects belonging to a young child. I believe there was a sign that sits in the room. There was also a crib and other objects, leading me to believe that that was the only child that occupied that room.
And you indicated that there was a sign of the names. Is there a child that the Ferriters have named?
That there is.
Did you notice anything else about that room?
Inside that room, there was also a small makeshift area that appeared as though there was a blanket and what appeared to be a pillow laying on the floor, but it was there kind of haphazardly. It didn't appear as anyone had slept there. It was just there placed.
Where is the next part of the house that you go to?
After looking in that room, I was directed towards near the Florida room. There was an area with a small desk. Mrs. Ferriter led me to believe that the children would do homework in this area.
Overruled.
So there was a small area for homework, it appeared. There were some writings that were told to me that belonged to.
Sustained as to that.
Without going into what was said, what was on the writing,
No.
or anything like that, what was the next place in the house that you went to?
The next place I went to was the enclosure in question,
Where was that enclosure found?
inside the garage of the residence.
And when you first went in there, what did you do?
When I first walked, so the enclosure is through the kitchen and into the garage. When I first walked through the kitchen and into the garage, I noticed that the door appeared to have a deadbolt, and there appeared to be a light switch on the exterior of the room outside to the left of that door. I then walked in and I observed a box spring and a mattress with what appeared to be some sheets. And there was also a small desk, a little bit smaller than this, that appeared to have some children's books on them. So I stood inside the room and I looked around for clues as to, where he may have gone, et cetera.
So I know while you were sitting down, you were motioning kind of like the length of what the witness stand was.
Yes.
Now, how long were you in that room for?
I was in the room less than a minute. I was inside the residence 5 minutes.
Now, after you finished viewing the room, where did you go next?
After I first walked into the room, I recalled that I could see something out of the corner of my eye, but I wasn't sure exactly what it was. So when I walked back out of the room, I asked Mrs. Ferriter if I could go back in the room. She allowed me to go back in. And when I went back in, that was when I saw the Ring camera that was in the corner of the room.
Now, after you saw that Ring camera, what was your next step in the investigation?
The next step, we were directed outside of the residence. I spoke to Mrs. Ferriter for several minutes outside of the residence, and then I directed other units that were working that evening to check in the area of some of the previous things, places that Mrs. Ferriter advised her son may have gone. So I know I checked the skate park. I directed other officers to check other parks and other areas that were within the surrounding area of where the residence was.
Now, I'm going to turn your attention to January 31st of 2022. Were you working that day?
That day I was.
Okay, and again, what was your role that day?
That day I was a detective, and my role was to continue the investigation in regards to the missing juvenile.
Did you become aware that the missing juvenile had been found?
That morning, I was made aware that the juvenile was located at the Independence Middle School.
And where did you respond to?
I responded to Independence Middle School.
Subsequent to that, did you meet with the juvenile?
I did.
And where did you meet with him?
So the juvenile, I met with him initially on scene, and then he was brought back to the Jupiter Police Department so I can conduct my initial fact-finding interview with him.
Okay, and you said fact-finding. What is that?
Just an initial interview just to find out exactly what I'm dealing with, exactly what the facts of the case may be, and find out exactly if there are any allegations of criminal behavior, et cetera.
How was he acting when you met with him at the police department?
He was very soft-spoken, very timid and shy, and appeared to be withdrawn and was very nervous.
Did you eventually get a statement from him that day?
I did.
Now, turning your attention to February 1st of 2022, again, were you working that day?
I was.
And did you make contact with the siblings in the case?
I did.
Okay, and who are they?
I made contact with both daughters. Ferriter, I apologize for misstating her name.
And did you take them anywhere?
Yes, they were brought to the Child Protection Team office in West Palm Beach.
And what is the Child Protection Team office?
The Child Protection Team is an office that's holds forensic interviewers, and they do our forensic interviews for our cases. So a more detailed interview than my initial fact-finding interview that took place.
So both were interviewed there.
That's correct.
And subsequent to that, on February 4th of 2022, was interviewed there as well.
Yes, he was.
Now, after all these interviews were done, what did you do as part of your investigation?
As part of my investigation, I served a search warrant, and I served and executed a search warrant on Ring, which was the camera that was inside of the room. And I began perusing the surveillance videos that were obtained through that.
So I know you kind of are describing the camera, but what is specifically Ring?
Sure. So ring.com, I'm not sure if you're familiar with, but Ring is a service that provides video doorbells. They also provide surveillance equipment and other things. And they are a cloud-based storage server. So anytime a video or anything is recorded through their service, it's uploaded and stored on their cloud server.
So you went ahead and executed that warrant for Ring?
That's correct.
And what did you get back from Ring?
Several thousands of videos, surveillance videos.
How many videos would you say there were?
Approximately 21,000.
And did you review each of those videos?
I reviewed a majority of those videos. I reviewed all of the videos in relation to the enclosure in reference to this case.
So when you say you reviewed the videos to the enclosure, were there other Ring cameras around the house?
That's correct.
Where were they?
There was, I believe, a front door camera, and I believe there was also another camera that captured an area in the backyard.
Besides the Ring search warrant, were there any other search warrants executed?
Yes.
What were those?
On February 8th, we executed a search warrant on the residence.
Your Honor, opposing counsel was confused and wants to have state exhibit 1.
Mark, can you make sure the microphone, the hand mic is at the podium so they can use it? Just cut it off until they're ready to use it. And but first, I want you to restate what you did. You were walking away, and I want to remind all counsel, you are being recorded, so you've got to be close to a mic. I'll even give you the portable mic that you can carry with you. Make sure you have a microphone with you, or you're at the microphones when you're speaking. So restate what you just said, because I didn't hear you, and I doubt it got picked up on recording.
On the record, I was asking Your Honor if I could approach defense counsel to show them State's Exhibit 1A through C.
1A through T?
C.
C is in Charlie. Okay,
Your Honor, may I approach the witness?
you may.
now showing the witness what's been marked as State's Exhibit 1A through C, if you want to just go over those
Thank you.
and then look up when you're done with them.
Sure. Okay.
And do you recognize those?
I do.
How do you recognize those?
These were our photos that were taken by my crime scene investigator that I directed to take.
And are they a fair and accurate depiction of what the house looked like on February 8th, 2022, when the search warrant was executed?
Yes, it is.
Your Honor, at this time, the state would enter into evidence State's Exhibit 1A through C.
Any objection? No objection. All right, so the court receives and accepts State's Exhibits 1A through C as in Charlie in evidence without objection.
Now, you stated on direct that you had your crime scene investigator take pictures.
That's correct.
Okay. You don't take the pictures yourself?
I do not.
And why not?
I'm not trained in taking photographs forensically, and our crime scene investigators take hours of training in regards to taking photographs, documenting crime scenes, etc.
Your Honor, at this time, permission to publish 1AC.
Granted. Okay, you're not using an Elmo? How are you doing it? Okay, all right, that'll be fine. Yes, it needs to be moved up. And right about there, I don't want you to obscure my view of the defense table. Okay. All right, so members of the jury, if we need to move it closer, I obviously will move it as close as it needs to be for you to be able to see it clearly. But if you're able to see it clearly where it is, that's fine. But if you're not, give me the thumbs up or thumbs down and we'll move it closer. Okay, good enough there. We'll leave it where it is then.
So for the record, I am showing State's 1C. What is this a picture of?
That is a picture of the open front door of the Ferriter residence.
And when you were speaking earlier about when you spoke to Ms. Ferriter, is that where you had been standing?
That's correct.
I'm now showing you 1A. And what is this a picture of?
That is a photo of the overall residence of the Ferriters.
Okay, and if we could go to 1B, what is this a picture of?
That is a picture of the exterior door from the garage to the exterior of the residence.
Now, when you first walk into the house, where do you go?
The foyer, it's like an open area that leads, not really a hallway, but there's a small wall, and then to the right, there's a bedroom. So in the first foyer.
Your Honor, at this time, I'm showing opposing counsel what's been previously marked as, sorry. You are. States 2AB.
2A through D or E?
A through B.
B, okay.
May I approach the witness?
You may.
I'm showing you what's been previously marked as State's Exhibit 2AB for identification purposes. You can look at it. Do you recognize this?
I do.
And how do you recognize it?
Again, this is a photograph of the foyer of the Ferriter residence, and it was taken at my direction, and is also in the area that I was standing and was brought into that first day.
Is it a very accurate depiction of where you had gone on February 8th, 2022 in the residence?
Yes, it doesn't look exactly the same, but it is a fair and accurate depiction of the residence.
Okay, Your Honor, at this time, the state would introduce State's Exhibit 2AB.
Any objection?
February 8th of 2022, when they executed the search warrant. Yes.
Any objection? All right, so court receives and accepts State's Exhibits 2A through B as in Bravo in evidence without objection.
And Your Honor, at this time, may the state publish?
Granted.
And just for the record, it is photos of the entrance of the house. For the record, it is State's Exhibit 2A. What is this?
That is the photo you just showed me of the foyer of the Ferriter residence.
Okay. And you stated that although this was how you saw it on February 8th of 2022, you said it was different.
That's correct.
How was it different?
So on January 30th, the first day that I was there, that credenza did not have those photos placed on it. Neither was that sign with whatever phrase that is, that wasn't present either.
Now publishing States 2B. And what is this a picture of?
That is just another angle of the same foyer.
Now, when I was asking you questions, you had indicated that there was a bedroom to the right when you first walked in.
That's correct.
Okay. Your Honor, I'm showing opposing counsel what's been previously marked as States Exhibit 3A through C.
C or D?
C. I'm sorry.
It's my hearing.
May I approach the witness?
You may.
I'm showing you what's been previously marked as State's Exhibit 3A through C if you want to look through them, and then just look up. Do you recognize those photos?
I do.
How do you recognize them?
Those are photos of the first room, Pierce's room, inside the Ferriter residence that were taken at my direction.
And are these photos accurate depiction of how you saw the room on February 8th, 2022?
Yes, it is.
Your Honor, at this time, the state would introduce into evidence State's Exhibit 3A through C.
Any objection from the defense? No objection. Court receives and accepts State's Exhibits 3A through C as in Charlie in evidence without objection.
Permission to publish?
Granted.
I'm showing you State Exhibit 3A. What is that a picture of?
That is a picture of the youngest Ferriter's room inside the Ferriter residence.
And on January 30th, did you see the bed like that?
No, in that room, there was no bed. There was only a crib and other items for a small child.
Okay. Turning to State's Exhibit C, 3C. And is that the crib that you had indicated?
That's correct.
Your Honor, at this time, I'm showing opposing counsel what's been previously marked as State's Exhibit 4A through D.
Thank you.
Mm-hmm. One with the covers on. Your Honor, may I approach the witness?
You may.
I'm showing you what's been previously marked as State's Exhibit 4A through D. Just go ahead and look at them.
Thank you.
Do you recognize those?
I do.
How do you recognize those?
Those are photographs of the same room, but this time the bed in that bedroom has the sheets removed, and they were photos that I directed our CSI to take.
Are they a fair and accurate depiction of how the room was on February 8th, 2022?
Yes, they are.
Your Honor, at this time, the state would enter into evidence State's Exhibit 4A through D.
Any objection? Court receives and accepts State's Exhibits 4A through D as in Delta in evidence without objection.
Permission to publish?
Granted.
I'm showing you State's Exhibit 4A. What is that a picture of?
That is a photograph of the youngest Ferriter room, which shows a bed without the sheets and a crib, and as well as some small children's toys.
Why were the sheets taken off?
When I observed the bed in that room, I recognized the sheets from these Ring videos, and I believe that that bed was the same bed that was previously in the room, or I'm sorry, in the enclosure that was inside the garage. So I directed my CSIs to remove the sheets and to photograph the bed.
Okay. Now publishing State's Exhibit 4B. And what is that?
That is a view of the interior of the room from the exterior.
And now publishing 4C. And what is that?
That's another photo of inside the room of the mattress and box spring.
Now publishing 4D. What is that?
That is a photo of the same room with the dresser for, as well as the sheets, et cetera, on the floor, and the mattress and box spring, and the crib, as well as some other children's toys.
Did you go to any of the other bedrooms in the house?
I did.
Did you go to any of the other siblings' bedrooms?
I did.
Your Honor, at this time, I'm showing opposing counsel what's been previously marked as State's Exhibit 5A through D.
Okay.
Yeah, I have to stop right here as part 1 and do the other 2 hours from today in the morning. And then after my doctor's appointment, I'll play all of day 2. But if I don't go to sleep right now, I'm going to fall asleep on my life. And we know what happens when chat goes wild, when a creator's sleeping. We're not going to try that tonight. Y'all have a good morning. I cannot keep my eyes open anymore. If you have not slept yet, please sleep well and have pleasant dreams. If you're waking up, please have a wonderful day. Hit that thumbs up for me. I have timestamp stopped, so we will start off in the morning. 2 hours left of this day. Thanks again. Hit that thumbs up, subscribe, pimp me out.